Bergman, the individual that we'd like to consult on legal issues associated to wills and trust and what you do in case of ill health for the elderly, also has an interesting a series of suggestions or recommendations for you to consider if you happen to be a child in those circumstances of divorce and there's a death, and interesting ideas you have. So the children of parents who are divorced face what in terms of inheritance?
Well, it's interesting. If the parents, let's say if you have a parent who did not died intestate, did not have a will, or
Okay.
did not have a trust. And so all the siblings are, it's kind of all up for grabs.
Okay.
There are intestacy laws about who it goes to. But then what if you have a child who was not part of a family, was a biological child, but the parent was never married to that child's mother, let's say. Let's say it was the father that died, and the mother was never married to the father. The father had other kids in a whole other family, and the child never really had a relationship with the father very much.
Interesting dilemma.
Yeah. Now, so the question is, does that child have any inheritance rights since he never was part of that father's main family,
Wow.
never really had a relationship with the father, and the parents were never married? Well, the answer in California is yes. And what you have to show is that that father did acknowledge that that child was his child at some point. And what acknowledge means under the law means that it doesn't have to be anything overt or that he necessarily lived with the child or anything like that, but just that he had maybe spoken to the child, maybe written some things to him, and kind of acknowledged in some way, whether verbally or non-verbally, through actions or words, that this was his child. And so by that, this child would have inheritance rights and a right to that father's estate.
Tricky moment. Well, and there you have it, yet another pickle of the law. Talk to you later.